Just to answer your question about the mandate, my mandate has just been renewed for 4 years. So let's start with that and do 4 years at the time. It's a very demanding job, so we need to have people with a lot of energy on board. So this is what I'm trying to do. So let's take it as a basis. It's a very demanding job indeed, but very interesting and intellectually very rich because we can discuss and address all children's rights, the interrelation between all those rights, and really see how much and in what extent we can ensure that children's rights are not only on paper but really applied. And we, as you know, probably we put a recommendation to state. We give them guidance on what to do and how to do. I think that everyone who is attending this webinar is very well aware of the context and very much convinced that we must act and act urgently to change the situation. And we know that the risk ahead of us are many, and especially when it comes to children. And so one of the main discussion today is how much we can give some space and some possibility for children to be part of the conversation and to be part of this the solution, also to look for a solution to address this crucial challenge that Kata has also kindly remind us in her presentation. Children will probably suffer, bear the consequences of the climate change and all the consequences of the environmental crisis much more than adults. And so that means that we need and we have to include and give a space to children much more. Indeed, as member of the Committee on the Right of the Child, I will, of course, base my intervention on the UNCRC that was already mentioned, and I will refer to the General Comment 26 on children's rights and the environment, and also in link with the General Comment 27 that is upcoming, that is dealing more precisely on access to justice and effective remedies. So if we want to ensure that children have a space, that their voice is heard, first of all, we have to remind ourselves that this is a right of the children. Children have the right to be heard in all matters that concern them. And we know, it's proven, that climate change and environment has consequences on the enjoyment of the rights of the children. And this is quite obvious for everyone who wants to honestly look at the situation. And so that means that we need and we have to ensure that children have this possibility to express themselves and to be active participants in the conversation about the future of the planet, but also their own future. And to be honest, we have to recognize that their voice are very often excluded from the decision-making process and in most of the conversation that we are having on the process. They have been asking for a space in the discussion. They have been demonstrating, even being on strike. They have been very active in all this context. And so we have to recognize all this. So what and how can we improve and make it and ensure that children have a space and the possibility to express themselves? And also to ensure that we are listening to all children, because we know that some children are even bearing a higher weight and a higher cost of the climate change. And they are usually the ones who are more excluded from vulnerable communities, from minorities, and they are really facing bigger problem and difficulties, including when accessing to justice and trying to claim their rights. And also, I think that it's very important to remind ourselves that if we want to involve children in decision making, we have to do it properly. It means that we have to empower children at the local level, starting from school, communities, and families. And it has to be done by providing them with the necessary tools, information, platforms to make informed decision and be able to take action. The children who are demonstrating, and many of them are very knowledgeable. They know what they want and they know what they are asking. And in many cases, when you listen to them, they just know more than most of the adults about what is happening. So their voice is crucial. And so the context and the environment in which to listen to them is very important. Besides creating the means and the platform to listen to children in a genuine manner, we have also to recognize and to acknowledge the fact that children have tried to use also legal avenues to challenge decision. And this is extremely interesting. They have been very active, supported by NGO, by other actors, UN agencies, and so on. And it's really interesting to see how much they have been active in this regard. But let us be frank. Access to justice remains a huge challenge for all of us, but even more for children. I'm not going to list all the barriers that exist in the field, but we know that there are financial barrier, procedural one, access to lawyers, access to lawyers who will listen to children and bring the case to a body or to a jurisdiction that will make a decision. All these are difficulties. Very often there is a principle that says a child doesn't have individual access to justice, and he has to be represented by the legal representative, usually the parents. And if the parents don't want, because they see it as a burden, too difficult, and so on, they don't want to represent their child, the child doesn't have any access to justice. So that's part of the barriers. And also the fact that it takes time, it takes money, it takes a lot of energy to make sure that there is this space. But still, we have a few examples, and it's interesting to see that a group of children have used legal procedures at national level, in front of the European Court on Human Rights, but also bringing cases to the Committee on the Right of the Child under the OPIC, the Optional Protocol on Individual Complaints, which is the mechanism to guarantee an access to justice to children at international level, specialized access to justice. And if I look at the decision that we have taken in this context, there is one famous climate case. You may have heard about it. 15 children from about 15 different countries have brought a case against 5 countries that have ratified the OPIC. That was a limitation. So the ones who have not ratified the OPIC cannot be brought to the Committee on the Right of the Child on that basis. And they were claiming that those states are among the worst polluters in the world, and they are not doing enough in fighting against climate change and environmental damages. And but they said, because it's a global problem, we have to go directly to a global jurisdiction, and we cannot exhaust domestic remedies. Fair enough, and I do understand their position. The committee said that the climate change has an effect on children's rights and the enjoyment of their rights by children. in many regards, on health, education, migration, and so on. So we do recognize that this is a children's rights issue. We did also recognize that there is a causality link between pollution, between the lack of policies addressing this issue and the enjoyment of children's rights. That was a second important dimension, because some states are still saying that we cannot prove that the pollution in one country has an effect on the enjoyment of children's rights in another country. Third dimension is precisely that one, is that the fact that pollution doesn't have borders, and children's rights shouldn't have borders, and obligation of states shouldn't have borders. So one state has obligation even outside of its territory when it comes to violation of children's rights. But still, we said that this complaint was not admissible, because we said it very clearly. It is first of all the role of the states to ensure and guarantee that there is access to justice for children at national level in domestic remedies. We know that children were disappointed by this decision, but I think that we gave them quite a lot of arguments to bring the case at national level, and among others, the fact that the states claim that they do guarantee access to justice at national level for all those children. So they can continue the fight at national level, and very often they can address all the decisions that are taken by the courts at national level. I have to speed up a bit. We have also a decision from the European Court on Human Rights that went along the same lines, but other decisions, not concerning directly children, but other decisions concerning climate change and environment that are more positive at a different level. Let me also mention a second case that is dealing with environmental issue. More recently, it was in September last year, we have received a complaint filed by three sisters. They were between 13 and 16 years old, from Finland, and they belong to a minority, cultural minority, the Sami nomadic herding community. And they live in, as you know, a nomadic community. Their culture is based on that. And they were claiming that Finland didn't listen to them when providing a company with the right to drill in their soil and in their traditional territory. So we looked at it, we heard the girls, and we heard their arguments that this decision is affecting the right to culture, the right to their own identity, their right to their own livelihood, and so on. And we noticed that they did ask at national level to be heard, to have their say when it comes to such decision, and they were not heard. And so we did say very clearly that Finland has the obligation to listen to children in such context, and when they decide to give a permit to drill and to exploit the soil that is belonging to a traditional community. And we asked Finland to provide with effective reparation for the violations suffered by those girls, but not only, you know, by providing damage, but also by ensuring that in the future they will be heard and they will have a proper access to justice in this kind of context. So these are a few examples of what we have been doing at international level to give access to justice. I should also mention that in the General Comment 26, we do give some guidance on access to justice for children in context of the environment and climate change. And we of course draw the attention of states about the obstacles that children are facing, but we also remind that states have an obligation to create judicial and non-judicial mechanism for addressing addressing abuse of children's rights by business, especially in case of extraterritorial impact. This is among other guidance that we are providing, and hopefully the next general comment will even be more precise on how to guarantee this access to justice and how to make sure that children have an effective remedy, judicial, non-judicial, with the support, even free legal assistance, and all the support that is needed to make sure that a right is a right, and if there is no access to justice, a right means nothing. I will stop here, and I'm, of course, open to any question and delighted to be a part of this discussion. Thank you.